A very good afternoon to all of you. I'm Pratyush Kumar from National Law University, Delhi, speaking on module Geographical Indications. First of all, the introduction. What is the definition and meaning of geographical indication? A geographical indication is a sign used on goods that have a specific geographical origin and possess qualities, reputation or characteristics that are essentially attributable to that place of origin. So, essentially any sign which indicates that a certain product originated from a particular place, and when that product has any quality attributable, such indication is called a geographical indication. Before we see some examples, it is essential that we consider two other terms, appellations of origin and indications of source. Indications of source. It is pertinent to state that the term has not been defined in any of the international treaties, though the term has been used in the Paris Convention. An example of an appellation of origin is champagne, which is used to indicate that a special kind of sparkling wine originating in the Champagne region of France. In India, Section 2(1)(g) of the Geographical Indications of Goods, Registration and Protection Act 1999 defines geographical indication in relation to goods to mean an indication which identifies such goods as agricultural goods, natural goods or manufactured goods as originating or manufactured in the territory of a country or a region or locality in that territory where a given quality, reputation or other characteristic of such goods is essentially attributable to its geographical origin, and in case where such goods are manufactured goods, one of the activities of either the production or of processing or preparation of the goods concerned takes place in such territory, region or locality as the case may be. For the purposes of this clause, any name which is not the name of a country, region or locality of that country shall also be considered as the geographical indication if it relates to a specific geographical area and is used upon or in relation to particular goods originating from that country, region or locality as the case may be. In other words, geographical indications are indications in any form used to identify a source of origination of a product, be it a naturally grown one or a manufactured one. They are primarily used for promotions by intimating the consumers of the source of a particular product. Now we will see the interlinkages between geographical indication and trademarks. The difference between trademarks and geographical indications is pretty simple. But before we embark on that, let us discuss a few similarities between trademarks and geographical indications. A first point of contact with which everyone is familiar is that both are distinctive symbols. Another point of contact stems from the foregoing, that is, both differentiate some products from others. However, trademarks differentiate the products made by different producers, and geographical indications differentiate one group of products from others and don't come from the region it protects. This property of a geographical indication makes it a collective mark. Another difference is that trademarks arise from the creative genius of man, while geographical indications are not created. They are there in nature due to the existence of human and natural factors. The third difference between them is that, unlike the case of trademark, social recognition must already be recognized before the idea and need for their protection arise. Geographical indications protection under TRIPS. Definition: a geographical indication identifies goods that originate from a particular place where a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. Provisions against misleading the public. Member states are required to provide the mechanisms that enable interested parties to prevent untruthful and misleading uses of geographical indications. In other words, tea growers in Nepal may not call their tea Darjeeling or Kangra, even if they are genetically identical to tea grown in Darjeeling or Kangra. In addition, literal truth is not a defense if the use of the geographical indication misleads the public. Therefore, tea growers in Darjeeling, which is a place somewhere else than the Darjeeling in West Bengal, India, may not market their tea as Darjeeling tea. Member states whose legislation would otherwise permit this use must refuse to register or cancel registrations of misleading geographical indications. Indian legislation, the GI Act 1999, provides exactly for this. Additional protection for geographical indications for wines and spirits. Article 23. Articles 23 and 24 provide broader protection for geographical indications for wines and spirits than for other products. An interested party need not prove that the public has been misled by the use of the indication in order to obtain relief. Even if the public is not misled by an advertisement for Saint Emilion style Bordeaux, imitation Calvados, or New St. George's quality wine, such a use violates Article 23. A grandfather clause, however, permits continuing uses of indications initiated more than 10 years preceding the end of the Uruguay round, or any good faith use initiated before that date. In addition, until a geographical indication is protected in its country of origin, rights acquired in good faith through use or registration of a trademark incorporating the indication are immune from attack. The additional protection for both wines and spirits includes three elements: the provision of the legal means for interested parties to prevent the use of a geographical indication identifying wines and spirits not originating in the place indicated by the geographical indication; the possibility to refuse or invalidate the registration of a trademark for wines or spirits which contains or consists of a geographical indication identifying wines or spirits at the request of an interested party. And last, the call for future negotiations aimed at increasing protection for individual geographical indications for wines and spirits. An extra additional protection by the TRIPS agreement for wines only emphasizes the need to accord protection for each geographical indication for wines in the case of homonymous indications and the establishment of a multilateral system of notification and registration of geographical indications for wines eligible for protection in the jurisdictions of those WTO members participating in the system. To emphasize the lack of protection for generic geographic indications, Article 24 expressly preserves the right to use geographical indications that are identical with the term customary in common language as the common name for such goods. Burgundy, Rhine, and Chablis for wine would seem to fall into this category within the borders of the United States, as certainly would Champagne. Although the French have worked hard to deter the generic use of champagne on naturally carbonated sparkling white wine beverages that do not originate in the region surrounding Reims, France, they have failed in the United States to influence the common language, in which champagne is the common name for sparkling wine rather than a source indicator. Arguments against protection would not apply, however, in countries where consumers expect that all Burgundy and Champagne come from France.